Okay, dear students, today we have a special guest in our classroom, which is even nicer because she's in person, which, as you know, in the time of COVID is not that common. So let me introduce my distinguished colleague, who arrived to give you a lecture from Taiwan, China, and Professor Wang is an expert on global intellectual property, cyber law, patent licensing, and chemistry and biotechnology industries. She is a well-known person in the world of IP. She was giving a lot of lectures and publishing a lot. So I have to admit that we also published one of the books together after the conference in New Delhi in India. It was in 2014. So it's my pleasure to have you here, Professor Wang. And as you can see, the group of the people is very, I would say, international. We have students from different countries, from Ukraine, Uzbekistan, France, Spain, Portugal, Malta, and it makes the lecture very interesting. And of course, it's also very good for us, for the students, and for me to have some more information about Chinese and Asian law. And I'm very happy to be a listener to a lecture, Monetization for IP, how AI and big data technology impact on intellectual property. And I think so the subject will be as well very interesting for the students. I know that you are an expert. And if you, dear students, have any questions, please do not hesitate to ask them. Professor Mei-Hsin Wang will answer them immediately. And I hope it will be an interesting lecture in the subject Introduction to Intellectual Property Law, which we already discussed some problems on copyright, design law, trademark law, geographic indication, and now patent law. So, Mrs. Professor Mei-Hsin Wang, the floor is yours, and you have 50 minutes for a lecture. And once again, thank you for coming, in person, which is even much more interesting having you here, in person than online. Thank you very much, and the floor is yours.
For Professor Jakub Kepinski, very kind introduction. This is the second part for our seminar, the monetization patent portfolio through AI and big data analytics. The first part, we have introduced how to monetization patents and the principles. Today, we would like to share you more true cases. My name is Professor Mei-Hsin Wang. As Professor Kepinski just mentioned, we have published books together through Cambridge Scholar Publishing. We have been friends since we met several times in the conference. This is a photo of my university. I sincerely hope after these two presentations, we can build out some mutual interest for future cooperation between universities. So students, faculties, we very much welcome you to visit us, and we firstly wish we could have more project together in all aspects. As my university is a top 3 in Science and Technology University in Taiwan, with many credited from IEET, AACSB, high rankings for industry income, impact ranking, UI Green Matrix World University ranking. We hope this is a good start, showing our good intention, and welcome you to Taiwan. Okay, so as I mentioned, we start a part, like full case for how AI, big data analysis impacts on IP monetization. IP and policy and politics, it matters. That's why Professor Kepinski and I always care about this environmental impacts from politics, from policy, from global economy. As you are aware, the China and US economic conflict based on the 5G and technology and many other goods and services, whatever. But technology war and commercial between US and China exists long ago. I will take this as example. Transmeta is a good company. He has a product ever been licensing or sold to many companies you know so far. NVIDIA, very famous AI company, Fujitsu, Sony, NEC, etc. But American government would not allow him export his technology service to China. Even the company were covered by Hong Kong, but Hong Kong belongs to China, right? He has no choice. Therefore, he turned his focus from selling service product to litigation. So he chose 10 of his patents to litigate Intel, and he won. He won how many? 250 million. But for a research and semicon chip design company, 200 million US, 250 million is not a big amount. They still did not survive longer. So finally, the company was sold. But if they have AI, big data, emerging technology long ago, for those 10 patents, we use the technology I just showed you in our first part, where I use pattern crawl and use Zeus analytics. We immediately found there are more potential infringer Transmeta can sue. You can sue National Semiconductor, you could sue AMD. AMD's mother company is fun, Dubai, Abu Dhabi. So they are rich. And then it's not only Intel are the target. Samsung, S3, HP, digital equipment, IBM, LG. So it certainly will survive much longer, or they could have some other partnership, as we just mentioned in our first part of the lecture. So those technology does help company to make their important decisions. But if we are helping those defendant, then we can, actually we have reviewed these 10 patents, and we found out they are not very strong, powerful patent. They are good patent, but not that much good, because they have many similar arts. As here you can see, with AMD, they have patent an application and also approved patents from digital equipment. So here, the system will immediately grab the similar patents worldwide. So you will find out new target or find out new similar arts. You may have new target to sue, to cooperate, to acquire, to merge, or you may also find your potential attacker, people who may hurt you or similar with you, similar arts, which may invalidate your patents. So if we are helping the potential target, then we will tell them you can use those approved the patent with B to invalidate certain part of the Transmeta's patent. So we have different strategy. So patent information, big data, they provide support for corporate strategy. Here you know if Transmeta would like to become a licensing company, like Cisco, Intervench, or MPAC, they have to apply the AI big data analysis, although they are no longer existed. So this is they help you to decide your corporate strategy directions and prioritize your R&Ds. Another capital management and monetization was never run. I would like to show you this case. I have shown you the securitized from Emory University in our first part. This is another case done by my friend with the president of LESI, and he's also the senior licensing attorney for J&J. You see, Ebola, you may have heard of it. Ebola, when you would broke out, they have the potential Ebola vaccine. So J&J acquired this medicine, this product, this right. We say they acquired this right. Johnson Johnson Development Corporation invest DKK 251 million, and then in the new Bavarian Nordic share. So it's a German company, and then total potential agreement, including the upfront payment, equity investment, milestone, supply contract is over 180 million. But I would like to tell you, on the day of announcement, J&J stock price up more than 2 billion. So those couple hundred million is not a big money because they continue stock up, price up for many days, and they have more capital coming in, so they could acquire more technology, more patent, more good service or product in the future. That's why, how could they be found? You must have, you yourself must be found online, and you must have the similar AI and big data database and tool to support you. And the other case I want to show you is how we train our students on the monetization strategy. This is the case. This lady, he has two patents, US 5252499 and 4904618. This is the patent family. For semicon patents, it's not a consumer product. If it's a milk powder or medicine, you must file a patent in every country because you have users. You may have competitors from everywhere. But if it's a high-tech, like semicon or some specific unique technology, big machine manufacturing, it only happen in certain country. Therefore, you don't have to file every country for patent profiling. So you see here only have EP, JP, Canada, Korea, because semiconductor is only, we not say only, the more powerful semicon countries, Taiwan, China, Korea, Japan, US, and the Europe company, they are often acquired. So it's not, you don't even need to file patent in Europe. But this is the case. I would like to show you what is the litigation strategy. I use this. So you may heard the solar panel industry bankruptcy all over the world. The company who survived, they are supported by the government, but LED industry, they did not, because they formed an alliance. I told you, form a patents technology alliance is a powerful major. So in old days, these four include is Japan, Nijang, Japan, Toyota Guzzi, Germany, Osram, Dutch, Philip, and American Korea, Cree. They are the 5 leading LED alliance. Therefore, they control the licensing. And Taiwan is very fortunate because we used to be colonized by Japan, so our product could still be sold, we get the licensing. But for China, they will never get the licensing from Japanese company. Even they hidden their original manufacturing location. If they will find out, Japanese company and Korean company will never use their product. So it's a very strong and powerful defense circle. The lady, for this LED industry, they have a supply chain, the upstream, middle stream, the downstream supplier. So the lady is friend because she's a scientist. She's not possible to manage all the litigation, but she's a Jewish. So the Jewish attorney they are powerful in IP field. So they sue Nijang, they sue Osram, they sue Cree, they sue Philip. And these 4 companies all settled with 100 million. Thereafter, they sued the whole supply chain over 30 countries, 30 companies, and they earn over 50 million. So this I would like to share you the strategy. You attack the leading company with a reasonable amount, not too high, not too low. Then the company will feel it may not worth to fight with you in the court, so they pay the settlement, and the rest of the middle stream, downstream companies, they all pay. Even the company are not on the defendant list, they pay to avoid the problem. So this is a case I would like to share you. And we review their patent value. You can see claim 1, 0. So it means this patent is powerful. As we mentioned, the claim 1 in patent is always powerful. And then this second patent, the claim 1 is 40. But we have done a couple hundred case studies. So patent value, the score, if it's around less than 50, they are good. 50, around 50, they are general in average. They are already in average. So in the end, the patent war was seized by patent crowdfunder. He found a document to invalidate one of the patents to seize the war. So by the time I would wonder if the patent could be invalidated, the previous company, those 30, 50 company who paid, should they be paid back? No, because the patent are really good. For claim 2, the independent claim for claim 10, claim 12, they are 0. That means the independency and then originality, the innovative, they are innovative. So you don't have a similar art to invalidate the patent, you have to pay. Of course, to invalidate the patent, not necessarily use the patent. You may also try to figure out whether during the prosecution period of time, whether there's other flaw you can apply. The other case is iRobot. The litigation may go on the general court, district court, then they may also go for ITC in the United States. So iRobot, he filed a lawsuit against all the cleaning robot companies. But one of the Taiwanese company, he issued a statement saying they actually win a case, but they spent 3 million for litigation, for attorney fee, and they also acquired patent from Ichi. But what I would like to show you is I train my student, and we use the rules analytic. We immediately find out many similar arts. So you don't have to buy new patents. You can simply write the analysis with the later, then and specify the similar arts, invalidate iRobot's patent. Then you don't have to pay. So this 3 million and the money for buying new patents, they were wasted. I have given a similar speech in China, and the company in China, they learned. So finally, this case was quickly settled. Okay. Another important reason why we have to apply AI big data analysis, emerging technology for corporate management. I would like to show you this case. Orinda IP, they sue 50 companies by using this patent, US patent 5438560. But the patent was originally owned by Hyundai Electron Industry. But how come the patent owned by Hyundai was sold out and be profited by a patent troll company? So this is the case I would like to emphasize. using the modern technology, a modern tool, you can have better management for your corporate. You can define and decide strategy, define the category pattern in your class in your own company. For those good one, of course, you keep it. For those not very good one, you may abandon it. For those middle class, you may want to enforce them or sell them for return on investment. You don't want your good pattern sold out and you keep paying those pattern with lower quality and let other company benefit from your original assets. That's what I would like to mention. This is another true case. The Varingo is an Israel MPE, and he sued China company ZTE. ZTE courageously invalid 40% of the claim, of their patent claim, but they still have to pay 21.5 million. If they did not invalidate 40% of the claim, they have to pay more. But how to invalidate that? That's how we told you. You need big data. You need to evaluate it. You need to make good strategy. So nowadays we have to rethink the patent investment. And now I would like to redraw your attention to thinking your patent investment. Should the patent be assets or debt? Of course, it should be an asset, not debt. Your certificate, of course, has to be a good asset, but how turn it to be a good asset? Before the preparation, you have to study. Prosecution, carefully amend your claim. Monetization, diligently. So that's how you could turn your asset become valuable, more profitable. And the patent management is not continuous invest process. It should be a continuous profiting process. Shaping the patent assets supported by continuous accumulation of big data is very essential. Otherwise, as you can see, you have to pay the fee, maintenance fee every year, and the maintenance fee is higher than higher. So if you don't work diligently to monetize, and you don't file your patent carefully, and you don't do prior study, then you just waste your money. So of course, it's a waterfall for the portfolio development, but for the claim strategy, you better think it in a portfolio management manner. So if you don't have the portfolio management thinking, the individual piece of the patent sometimes it's difficult to be very effective. Although you have seen some litigation case, they were just using one single patent. But that's for litigation. Apart from litigation, we have so many means to monetize patent. We can partnership, we can securitize, we can tokenize, we can licensing, right? So there are so many other ways to make money. So thinking patent as a whole strategy and corporate direction is very important. And the left is a life cycle management from the preparation, prosecution, and monetization. So in the preparation stage, we have to do the patent landscape search, competitive intelligence analysis, state-of-art search. And then when we start the prosecution, we have to think of the portfolio assessment, evidence of use, and then forward citation analysis, patentability search, same or similar tag, and then monetization stage, we have to do invalidation search, patent clearance search. Okay. The life cycle management, the third-party patent portfolio, we can use AI to do very comprehensive analysis. And I would like to show you in the case. So we have to know the ecosystem of the industry to create competitive building block, identify the state of art and key player to optimize resource citation allocation, and figure out the potential monetization target to develop strategic patent portfolio. And this is an example. If we want to, the lead indicator for commercialization, the goals, the function has to be synced. For example, if we use sensor as the case, the sensor could be used a vehicle dynamic stability for information comfort. That's when we use the auto driving. For the auto driving, then we need a lot of sensor. And the sensor, they have different company, the LiDAR, radar, infrared sensor, vision sensor, multiple sensor platform. You may think of a lot. And for the function, different function. For the automatic cooperative driving, so different function, different goals, and different type of product all have to be searched. So we can categorize different manners and make it a matrix analysis. For example, the vision-based sensor fuse technology. If we toward this direction, then the US UP stream, the company competitor, the upstream, there will be Hitachi, Fujitsu. The middle stream, we have Google, Continental, Denso, Robert Bosch, Magnum, Mendo, Gentex, Mobileye, Delphi, Valeo, Autolife. For the downstream user, all those car companies, Hyundai, Toyota, Ford, GM, Nissan, Fuji, BMW, etc., and other American vehicles. So we will have to trace their patent application year by year. That's one of the monitoring. And then we may also would like to calculate the ownership percentage. Percentage is important, number is important. And we would like to identify where are those patents allocated. Are they the radar, infrared, ultrasonic, or LiDAR? What technology they have been applied? And also, if we want to further dig in the LiDAR development, we may have to also study the major competition. For example, we have to study carefully the manufacturer many from China, right? So the China companies, Chinese data company, they start to apply patents in a very high rate. In the past, they did not. And other LiDAR company, most startups have steady growth, but after 2016, it became more aggressively because auto driving become or cooperative driving become a trendy fashion in the future. So for those claim technology analysis, we may also analyze corporate. Previously, we based on the technology. We can based on the corporate to analyze corporate strategy and their patent strengths. This is another way we did. For the objective for prosecution stage, we figure out the scope disclosed in the prior art and combine it with the competitor patent product information for strategics, oral actions response to the patent office, and competitive patent portfolio. We know patent and market data are the substitute technology for evaluating the maintenance and regrouping the portfolio. For the pattern mapping, they have different type of map. You can see the real map, you can see the pie chart, you can see Gantt chart as we see in those. So different analysis, company-wise, supply chain-wise, application rate, application numbers, major competitive corporate studies, or examination behavior by legal analysis is also important. We may would like to know what happened in US, the trend, or this field, the particular interest in industry, the litigation up or down, what's the situation, and what is the current trend in China is also important. And we allocate you can reallocate your IP resource on high-performing portfolio by competitive intelligence. For example, Samsung, Micron, SK Hynix, Toshiba, Intel. They may have different patents portfolio. As here we can see, we categorize their A class patent. This is quality-wise and value-wise. We can quality-wise and value-wise then keep the best patent and abandon the rest the patent. We sold them or we just give up. So for corporate management, it's important. And you can see whether you can buy patent from some other famous company. This strength analysis is also important. Our next case study is about the cardiology products. So we will have to study radiology, cardiology, from the time frame, how many patents have been applied, and who is the main player in the field, the product structure, and the technology structure. So that's the matrix, product-wise and technology-wise, and then we can figure out the best patent. Because in the system, if you click these numbers, you can retrieve the patent number and for further study. So here you can see 2010, 2013 half-row portfolio as mainly focused on the heart modeling product. Besides from the technology aspect, this patent focused on the modeling of the coronary artery. 2014, 2018 half-row portfolio will expand, and the disease detection, intervention planning, and user interface has significant growth. And from the technology aspect, and this patent focus on physiology model, image reconstruction, and disease detection and surgical planning. So you can understand big data analysis, AI, and this pattern mining. They could give you different directions and different studies for your research and product development. So the objective for the monetization stage, we have to leverage the pattern big data, identify potential monetization target in a minute, and then leverage the pattern big data, identify potential prior art for invalidating, then dig deeper into the target pattern portfolio, evaluate benefit of the investment, decide you want to invest them, you want to cooperate with them, you want to invalidate their patent, or you want to join them, or you want to acquire them, whatever. So value highlight for patent against the potential target. We always have to study the trend. So the highlight of the patent family in the portfolio that may be used against applicants and from a licensing for enforcement prospect, we can further filter the result and analyze potential target on the market, as we have done. For prior art funding, we can uncover the potential validated issues. It will be whether your patent could have, who could possibly invalidate your patent, or you could invalidate your competitor patent. So the degree of prior art, there could be the reference you found that, but could also reference to reference the software they could dig in, figure out. So hierarchy. Another example we want to show you is the sensors. So we can have the technology hierarchy, manufacturer hierarchy, and breakdown. So we can have the filter year and US patent in the view. Also the years and their legal actions, whether they have continued application, continue in part application, or their division, study their patent family. And further study where is the key technology with important patents. This is another way for presentation. So now you can see patent analysis have a very profound wisdom there, but we also would like to draw your attention to the current development. The previously. That's our maybe my prejudice, but it was also true. U.S. legal profession is no longer exclusive drive their U.S. intellectual property law to threaten the world. So intellectual property increasingly controlling the legal profession and the practice of the law. Technology and intellectual access are forcing the legal profession to adopt AI, machine learning, big data analytics, automation, DIY law, chatbots, privacy, data security, and virtual lawyers. But will it change the legal profession? Also cause the other change as well. Of course, copyright, time shifting, and space shifting. AI can be the copyright owner, can it? AI somehow they can draft news or create articles somehow better than the kids. Patent software and anything under the sun they made by the man could be patent, but can AI be the patent inventor? But AI can draft patent better than the beginner because they have the module and trained by experts, senior experts. Sometimes they wrote better than the beginners. And trademark, the smell, the color, the sound, they can be trademark. Patent drafting, smart contract, inventorship, ownership, all being challenged by the new technology. Prior search can be done by AI. AI can draft patent, articles, patents. Patentability determination can be supported by AI's machine learning. Patent acquisition, where to find the potential target can be supported by AI big data analysis. Patent assertion can be supported by AI, and patent and intellectual property investment can be supported by AI and big data analysis. So it's a little nothing more than just a process, can be called it, of course, wisdom, sometimes value. Somehow. Okay. So is an analytic engine better than an emotional human being? Sometimes. If some software always there and always on, is it good? We also need rest. After AI, automation, machine learning, are we live easier or more harsh? I think we have to work more and work more diligently and smarter. So lawyer no longer need to have office, can crowd-based law firm adequately protect client? Are lawyer more subject to hack and intrusion? Can the video lawyer ethically represent in client? Or what does a lawyer offer? Are lawyer responsible for protecting the intellectual property that might eliminate or change the profession? Or can experience and intuition be more coded or machine learning? Of course, for this moment, not yet, but in the future, we don't know. But however, working with machine will be the trend. And this is my presentation. So welcome your questions, and I'm very happy to answer you. And thank you, Jakub.